As Dov mentioned, I am a philosopher. I am a bioethicist. I'm a feminist bioethicist, and I'm also from Canada. I don't have expertise in American law around these issues. My husband happens to be a law professor, and I have turned to him to make sure I'm not saying anything dumb about the law in talks that I give about conscientious refusals. So if I do say something like that, you can tell him about it. Okay. So this situation is really what prompted me to come and give this lecture. It's quite a shocking turn of events in my opinion. The situation is not quite as dire in Canada. Although there are many places in Canada, you might think Canada's, it's much better. If you're, definitely in favor of abortion access, Canada would be a good place to go. But in fact, the situation's fairly bad there, especially in remote locations in Canada where it can be impossible to get abortion access. Reading Dov's work, he alerted me to this nice podcast that gives responses of abortion providers to the overturning of Roe v. Wade. I've given a few of them here. One response is despair. I think we'll see a lot of women die and a lot of unfortunate situations happening. So many women, especially women who grew up poor like me, they're not going to be able to fly to California or New York. Another response, and this is one that Dov quoted himself, or has quoted in his work, this is about the status of women and whether they are full, capable societal equals to men. I'm a conscientious provider. It's part of my moral and religious worldview. The person who's pregnant knows what's best for them. And lastly, and this person is just named Jennifer, they're not given, the full name is not given in the podcast. I just feel like if that's what's going to have to happen to me, a felony charge, to continue to give these women the support they need, then I'll take it. Two things I want to emphasize from these quotes is that, these physicians are certainly making moral claims. They're expressing moral concern about this situation. They're concerned about pregnant patients' health, their lives, their autonomy. They're concerned about what's called reproductive justice, which is equality and access of reproductive services for people from different social groups. They're concerned about the status of women. So they're definitely making moral claims. Another point I want to make is, I think in saying that they, in feeling compelled to provide the services despite what the law says, which some of them are indicating, they're being compelled by their conscience. Dr. Eisenberg is saying that explicitly, and the last physician there, Jennifer, is saying that ultimately that she will provide that service regardless of what the law says. Okay, so if she's motivated from conscience to do that, she is what bioethicists and law professors would call a conscientious provider. And let me just give a sort of definition of what that is. So the literature in bioethics and in law refers to conscientious provision and conscientious refusal. Okay, these are both forms of conscientious conduct by healthcare professionals. It's conduct motivated by conscience. So conscientious there refers to an action motivated by conscience, not simply one that's careful or considered. And it's action that opposes the law or standard of care. Okay. So these terms are used fairly narrowly to refer to action that is opposing the law or standard of care. Right? So someone doesn't engage in conscientious provision if they're doing what the standard of care requires of them, according to this definition. Okay. Conscientious provision specifically is providing care that's prohibited by law or health policies. It could be a hospital policy that's prohibiting that, like the policy of a Catholic hospital. And often that care, right, meets accepted standards of medical practice. It needn't necessarily, but in typical cases of conscientious provision, it meets the standards of medical practice. And that's true, I think, of conscientious provision to provide for abortion right now. Okay. I'm understanding that term similarly to the way Liz Sepper does in a nice piece that she wrote in 2012. So conscientious provision, or conscientious refusal, is refusing care that makes up the standard of care, okay, refusing that based on conscience. And, one thing to emphasize about both these forms of conscientious conduct is the care being provided or refused is normally requested by the patient, okay? So this is care the patient is coming to the healthcare professional to get, assuming that they can get it from them. And in the case of refusal, the physician is saying, I can't do that on grounds of conscience. In the case of provision, the physician is providing that care despite the fact that they're legally not allowed to provide it, or their profession, expects them not to provide it, okay? Okay, so a lot of the literature now and discussion about this started really about 10 or 12 years ago, but it's really coming to the fore now. There's discussion about what I've termed here an asymmetry in the protection of conscience. So there's substantial protection for conscientious refusal. That's true in the United States, it's also true elsewhere. But there's little to no protection for conscientious provision. I think in a recent piece that Dove wrote, he mentions that Vermont, I think, is a state where there may be some protection for conscientious provision, but that's very unusual. And it's not just unusual in the United States, it's unusual in other places as well. Okay. I've noted the situation is similar in Canada. In Canada, the rules around how much protection conscientious objectors get is given by provincial colleges of physicians and surgeons. So the rules can vary from province to province, but that's where the sort of regulation comes from. So that situation, that asymmetry, has spurred this debate. It's occurring in bioethics and in law over whether conscientious provision should be protected as much or more even than conscientious refusal, okay? So it's whether those exemptions that Dove referred to should be given to both, physicians who want to provide services because their conscience demands it, that the law or policy won't let them provide, and similarly with the refusers, whether, so the question is, should it be equal? Should there be equal protection, or perhaps an opposite sort of asymmetry to what we have now, okay? So what I want to do today, I certainly don't want to settle that debate. I think it's very complicated. I think the whole issue of how morally to regulate conscientious provision and refusal is quite complicated. I've been looking at this issue for, over a decade. I wrote a book about it that came out in 2020. Coming back to this issue after having not looked at it for a few years was, I'm happy to do it, but it was a bit exhausting because it is a really complicated issue. So what I want to do is just discuss two topics that are relevant, two issues that I think are really, really important in thinking about the regulation of this conduct, and that's the value of conscience and the professional role of physicians. I was asked initially just to talk about the value of conscience, but I didn't want to just do that, partly because I really wanted to talk about the conscientious provision of abortion, which I will talk about more when I'm talking about the professional role of physicians. So two questions I'll focus on, and they concern how bioethicists react to these issues. In the draft that was circulated, I focused more on my own views about the value of conscience and the professional role of physicians. I've sort of broadened things out for the talk to make it more accessible, I think. So one question, when focused squarely on the value of conscience, so they're just thinking about that value, what conscience is, why it's valuable. How would many bioethicists respond to that asymmetry in protection for refusal and provision of abortion? Okay. So if they're, again, just focused on that one issue, what would they say about that asymmetry? And secondly, when focused also on the professional role of physicians, how should or would they respond? Okay. Just one thing I want to note, I am going to focus on physicians as healthcare professionals here, and I'm doing that just for simplicity. They're not the only healthcare professionals that are relevant to this discussion. There are others who are essentially abortion providers. Pharmacists play a significant role in providing medical abortions. In some jurisdictions, midwives do, nurse practitioners. So I'm just focusing on physicians for simplicity. In my book, I talk about other healthcare professionals too. Okay, so first, the value of conscience. So again, here's the question again, when focused squarely on that value, how would many bioethicists respond to that asymmetry? And let me just give you an overview here of what I want to say, and then I'll elaborate. So the answer obviously rests on how they understand the value of conscience. There are some bioethicists who suggest that conscience has little value, in medicine at least, but many others disagree. I think the dominant view in bioethics is certainly that conscience has value in medicine and elsewhere. So many say, as I've noted on the slide, that something important is at stake in preventing all, or at least most, physicians from acting on their conscience. And I'm one of those people. I say something's important at stake in most cases, not all, but that, I think, point isn't really important at this point. So they wouldn't discriminate also between conscientious provision and refusal. So they would say something is important at stake in preventing a physician from acting on their conscience, regardless of whether we're dealing with a case of conscientious provision or refusal. Okay, so they would oppose that asymmetry. So in answer to the question, they would reject that asymmetry and want to replace it with a symmetrical form of regulation. Okay. Again, this is just if they're focused on that issue of conscience having value. So let me elaborate on this. So what's at stake, according to many bioethicists? Again, what's at stake in preventing physicians from acting on their conscience? They don't say that what's at stake is our grasp on moral truth necessarily. So they don't have this view of conscience, which does exist in the literature, and Professor Smith will talk about this, that conscience is a guide to moral truth. That if we listen to our conscience, listen really carefully, right, it will tell us what the morally correct action is, okay? So their grounds for rejecting that sort of view of conscience is, I think grounds that many people would have. The first one, skepticism that conscience could be a little voice whispering to each of us infallibly about what we should or should not do. So if conscience is objective, it would be that little voice, right? That little voice telling us that what you're thinking of doing, right, is wrong and you ought not to do it. And it's objectively wrong if it's the voice of moral truth. Okay, so bioethicists are skeptical of that. They also think that if we understand conscience objectively, and this is from Mark Wickler, that would sound the death knell for conscientious objection in healthcare and the practice of accommodating healthcare professionals with diverse and often conflicting conceptions of a morally decent life. Okay. So in other words, if we really thought that conscience was objective, and physicians who make conscientious objections are truly listening to their conscience when they make those objections, then we wouldn't accommodate them within our existing policies. What we would do is change the policies, right? Because their conscience, if they're truly acting on conscience, and conscience is the voice of moral truth, then what their action is telling us is our policies are wrong-headed, right? We need to change them. We wouldn't give them, special exemptions, right? We would just change the policies. So, what that view suggests is when we're talking about, conscientious refusal and provision in terms of giving exemptions from what healthcare professionals are expected to do, we can't be working with an objectivist view about conscience, okay? So bioethicists view conscience in a subjectivist way instead. So for them, conscience, and what a conscience does, is encourage people to act in accordance with their own subjective, secular, or religious moral values. Okay? So if that's what conscience is, though, immediately people are going to ask, Why should we care about whether people are able to act on their own subjective moral values, right? If they're not the correct values, they could be completely wrong-headed. Why should we care about whether people are able to act on those values? And the answer bioethicists give, and they're not alone in this, is moral integrity. So ultimately, what listening to your conscience allows you to do or to have in the end is moral integrity. Okay. And as I've stated on the slide, so the idea is just allowing people to act on their conscience has this consequence that they're able to have or sustain their moral integrity. Now, as I note in my book, it might seem odd to point to this entirely different thing, moral integrity, to describe the value of conscience. Okay? But this sort of view can explain common intuitions we have about conscience, and I've just given a couple of examples on the slide. The first comes from the bioethicist Jeffrey Blunstein. Making an appeal to conscience to avoid having to do Y, some action Y, is different from making the judgment that Y is wrong. The appeal expresses something new, arguably a concern for integrity. Okay? So when I make an appeal to conscience, I'm not simply saying that in my view this is wrong. I'm saying something else. There's something in addition, right? And these bioethicists say it's a concern for your own integrity. Another point, it makes no sense to claim, this comes from Gilbert Ryle, my conscience says you ought to do this, right? That doesn't seem to make sense. We don't use the term conscience in that way. My conscience tells me that I ought to do this. It doesn't speak about what others ought to do. As I've noted here, the focus is on what I do, the concern is for me, and again, arguably for my integrity. Bioethicists say additional things like this sort of view of conscience helps to explain the dramatic language that accompanies an appeal to conscience, like I wouldn't be able to live with myself if I did that. I wouldn't be able to look at myself in the mirror. So there's this concern for me and my moral integrity, and ultimately, as we'll see, for my own self-respect. Okay. So on this view, the value of conscience just is the value of moral integrity. And you can ask again, so what's the value in that? It just sort of pushes the question further, right? Bioethicists do give somewhat different answers. They tend to work with different conceptions of moral integrity, and I've listed them there. I don't think the details matter so much. My own view is definitely distinct from what I think is a more dominant view, that integrity is about wholeness or having an integrated self. But I don't think these details matter. I think ultimately, bioethicists agree the value of conscience lies in the value of moral integrity, and moral integrity has value because it promotes self-respect or the lack of self-betrayal, right? Being able to live a life where you're not riddled with guilt and regret because you violated moral principles that you hold dear. Okay. So that's the sort of framework about conscience that bioethicists are working with. How is that framework relevant to that first question that I've raised, to when focused squarely on the value of conscience? How would they respond to the asymmetry? And basically, they would object to the asymmetry because they would have no reason to think that with conscientious refusals, but not conscientious provision, the provider's or the physician's moral integrity is at stake, right? So as I've noted, they would reject the idea that with refusals alone, physicians are striving to maintain their psychological unity, act on identity-conferring commitments, or simply act on their best moral judgment. I think no matter how they think of integrity, they would say integrity is at stake in either case. I think that's pretty straightforward, okay? So the response to my Q1 is just that the value of conscience speaks against that asymmetry and in favor of symmetry. Okay. Before moving to the next issue, I want to discuss the professional role of physicians. I just want to say, and this explains partly why I'm moving to that. Bioethicists don't believe that conscience and or the value of conscience is the only thing that matters when regulating conscientious refusals or provision in healthcare. Okay. As I've noted, there are other considerations. One big one has to do with who is engaging in that conscientious conduct and what role they have when they're engaging in that conduct. Okay. So the moral issues of valuing conscience and valuing conscientious conduct are distinct. And I'll move now to talking about just valuing, in particular, the conscientious provision of abortions. So this has to do with the professional role of physicians. So the second question I have is, when focused also on the professional role of physicians, how would, or at least should, bioethicists respond to the asymmetry? Many do describe that role as fiduciary, right? It's a common claim in bioethics that physicians are fiduciaries. They tend not to theorize a lot about that, the way they've theorized about conscience. But I do that as a bioethicist in my book. I've shown you the cover. I quite like that cover. So if that's true, if physicians are fiduciaries, and bioethicists accept that, they would have to consider then whether that role permits conscientious refusal or conscientious provision, or one and not the other. I think, again, if they're focused on that role, they would have some reason to accept an asymmetry that's the opposite to the one we have now. So an asymmetry where there's more protection, in fact, for conscientious provision than conscientious refusal. Okay. So insofar as bioethicists are committed to this idea that physicians are fiduciaries, right, I think they have some reason, at least, to accept that opposite sort of asymmetry. I'm going to be more tentative here because, the issues here are very complex, and I'm just going to be able to sort of outline an argument. I think my conclusion in the first part of the talk is more sort of definitive. So we'll see how this goes. Okay. Ooh. So let me just describe this sort of framework of physicians being fiduciaries. It is a role, that's certainly been defined mostly within the law. And the fiduciary relationship, I think, is a distinctively legal relationship. But we can talk about just its moral dimensions, and that's what bioethicists are interested in. That's what I'm interested in, and any claims I make about what physicians are required to do as fiduciaries are purely moral claims. Again, I'm not a lawyer. So I did, though, get quite a bit of help from law professors who focus on fiduciaries when I was thinking about this stuff. So I went to a couple meetings of this global group of fiduciary people, had some, sustained discussions with Paul Miller, who's one of them, Evan Fox Decent is another, and Lionel Smith. But it's Paul Miller's sort of view of a fiduciary that's really influenced mine the most. He describes the fiduciary role as one that involves having a certain kind of power, and I've laid that out on this slide. So it's power that's discretionary versus just bare power, like the power of a crossing guard to get traffic to stop. So it's power where there's some room to exercise your own judgment in using that power. It's power in the form of authority. So the person is authorized to do what they're doing, and normally that authorization comes from the other party, who's described as the beneficiary in the law. And it's authority to set or pursue significant interests of that other person, normally within a certain sphere, so the sphere of their health or their finances, for example. Sometimes it's not, limited to a certain sphere. So parents are fiduciaries of their children, for example. There's a lot of responsibility that goes along with parenting, as many of you probably know. And there's a lot of power. It is power of this sort, power that is discretionary, power that you're authorized to exercise over your child, authorized by the law. And it's authority to set and pursue significant interests, including welfare interests, whereas a parent, it's all the welfare interests of your child. Okay. So a fiduciary role involves having that kind of power, and it involves also having a duty to use that power and any relevant expertise that you have to further those interests of the beneficiary. So the beneficiary, when they authorize you to act as their fiduciary, they're authorizing you to pursue certain interests, right? And to use your sort of expertise, if that's relevant to the relationship, to use that expertise when exercising that power. Okay. So, as I've said, I think bioethicists and many others believe that physicians are fiduciaries. Physicians do have that sort of power over patients, and that's even true of competent patients, so patients whose autonomy they're required to respect. So some people have argued that this model is not a good one of the professional role of the physician because physicians have to respect the autonomy of their patients, and some see this model as being quite paternalistic, that the fiduciary is meant to act on behalf of the other. That sounds like a paternalistic relationship. But I argue in the book that, even with competent patients, physicians are fiduciaries. And I've just listed a few reasons why. They have discretionary authority over whether those competent patients will receive access to healthcare services. So they are gatekeepers of those services, and they exercise discretionary authority in deciding who's going to get them. They exercise that authority in deciding how or whether patients will be informed about their healthcare options, how their autonomous decisions will be acted upon. So even where they have a patient whose autonomy they're required to respect, there's room for their discretionary judgment and for them to act really on behalf of the patient. Okay. So if they are fiduciaries, right, of patients, they are obligated to decide those things and other things with the patient's health interests in mind. Right? They need to give the sort of language we use in bioethics, they need to give primacy to patient interests. Okay, so that's, in short, the fiduciary framework. You can ask, how is that framework relevant to my second question, Q2? When focused also on the professional role of physicians, how would or should bioethicists respond to that asymmetry? And as I've said, they would consider whether the fiduciary role permits the conscientious refusal of abortions, but not their conscientious provision, which is what the asymmetry says or does. They would question more specifically whether there's a misuse or abuse of fiduciary power in either case. Okay. So the refusals would not be permitted if there's some sort of misuse or abuse of that power, similarly with conscientious provision. And I'm going to look at how the power is used in either case, and I think looking at that should lead, bioethicists to at least consider to supporting conscientious provision more than refusal. Okay. So what's the use of fiduciary power with conscientious refusal? And this is an argument that I give in chapter 5 of my book. With refusals, physicians are deciding based on their conscience alone whether or when or where patients will access the abortion that they seek. But the patient hasn't consented to them using their power in this way, using their power where they're consulting simply their conscience in deciding how to act. As I said earlier, when patients authorize physicians to act, what they're authorizing or consenting to them to do is to use the power that they have and their medical expertise and knowledge of the standard of care and to provide them with that care. So they haven't consented to them acting simply on their conscience. Similarly, as I've noted on the slide, they haven't consented to their physicians prioritizing their own moral integrity over the patient's interest in accessing care. So I think it's certainly true, at least in some cases of conscientious refusal, that what the refuser is doing, right, is expressing that concern for moral integrity that we discussed in the first part of this talk. And what they're doing when they're refusing, stepping back, is they're prioritizing that moral integrity over the patient's health interests. But again, the patient hasn't consented to that. I do think in some cases of conscientious refusal, and I talk about different scenarios in the book, what the objector is doing is actually prioritizing the interests of what they perceive to be their second patient, the fetus. They're not actually prioritizing their own. I think in some cases they really are just prioritizing their own moral integrity. But in other cases, they're prioritizing the interests of that second patient. And I respond to that by saying that, again, they simply don't have the authority to do that. No one, not the pregnant woman or the state, right, has granted them the authority to prioritize the interest of that second patient especially in those cases involving abortion access. So I conclude, and this is my view, that their actions amount to a misuse or abuse of power. Okay, and based on that, I argue in favor of quite serious restrictions on conscientious refusal, on giving those exemptions to conscientious objectors. So there's a group of bioethicists who have this view, who think that there should be much less protection for the conscientious refusal of care than there is in many jurisdictions. Now, you could argue the opposite. You could say, well, I accept that there's a misuse or abuse of power in these cases, but you might say, there's still some other value. The value of conscience trumps that. You could say, I recognize there's this misuse of power, right? But being able to act on your conscience and sustain moral integrity is just more important. Or being able to save the interests of that second patient is just more important. You could go that route. It's not the route that I go. Okay. With conscientious provision, things are different, somewhat different. The patient is deciding based on their conscience, and we're focused here on abortion. They're deciding based on their conscience and accepted medical practice whether or when or where the patient will access an abortion. And in these cases, mainly because the patient is the one requesting this care, they have consented to the physician using their power in this way. Unlike with conscientious refusal, they are exercising discretionary authority rather than mere power. So it appears then, and I'm simply saying it appears, things are complicated here, and they'd have to do a lot more to argue definitively in favor of this view. But arguably, they aren't misusing or abusing their power. Instead, they might actually be using it properly. Okay. So this is the sort of line of argument you could try to run to say that a new asymmetry is in order, right? The opposite to what we have now. So again, particularly if you're focused on the professional role of physician and you believe that role is a fiduciary one, I think you could run this line of argument to say that we need a new asymmetry. Okay. But, so again, I've focused on those two sort of values, conscience and the professional role of the physician, but they are not the only ones that matter here. As I started out, this issue is very complicated, right? Many bioethicists themselves wouldn't say these are the only values that matter, and this literature is very rich, and they talk about, other sorts of values that are important. I've noted here just one sort of politically relevant sort of issue. This is something that Doug Fox has talked about in his work, but also Kyle Fritz, the bioethicist Kyle Fritz. There's some issue about whether the protection for conscientious provision is irrational because it undermines the state's interest in prohibiting abortions. So if you're protecting conscientious provision of abortion, but at the same time you've said abortions are illegal, it's not clear how that's really consistent, right, to have that. Whereas, protecting conscientious refusal and saying that abortions are permitted and physicians are expected to provide them in certain circumstances, that sort of position doesn't seem inconsistent. At least if you're providing some means for patients to get abortions from people other than those who conscientiously object to them, right? So you think the provision of abortion is important, that seems consistent with allowing at least some physicians to be exempted from having to provide them. Right? But saying abortion should be outlawed doesn't seem consistent with saying, yes, but we'll let some physicians conscientiously provide them. So that's just yet another issue that we would need to consider. Okay. So just to conclude, I've tried to give you a sense here about what some of the literature at least is like in bioethics about conscientious conduct in medicine. I do think many of them would question the status quo about the protection for conscience in medicine, so that asymmetry that I started out with. The value of conscience alone, as it's understood by most bioethicists, suggests that the conscience of physicians who are committed to providing abortions deserves as much protection as the conscience of physicians who refuse to provide them. I can't see any reason why bioethicists would say otherwise. And it may even be appropriate to protect conscientious provision more because of how physicians wield their power when engaging in these different forms of conduct. Okay? Arguably, they wield their power appropriately, or at least more appropriately in the case of conscientious provision than with conscientious refusal. And I think a lot of the reason there has to do with the fact that what they're doing aligns with what the patient wants, what the patient has requested. And I think it's also important, in the case of abortion here, that it aligns with what accepted medical practice is surrounding the care of patients in unwanted pregnancies. Okay, thank you, everyone. I hope that wasn't too long. Do you want me to get out of here?
Yeah, sure.
I don't know if anyone else is using it.
Thank you so much, Carolyn. That was wonderful. So much of what I myself and so many others have learned about the meaning of conscience come from your scholarship and from our next speakers. Everything I have learned about the law in this area comes from some of our other speakers, Nadia Sawicki and Liz Sepper, who Carolyn's work mentioned as well. Next, we are going to hear a response to Carolyn's provocative claims about conscience and its application to our current moment in law and society with respect to healthcare professionals and the provision of abortion care. We are going to hear from Stephen Smith, who is the Warren Distinguished Professor of Law at the University of San Diego School of Law, where he also directs the Institutes for Law, Religion, and Philosophy. Professor Smith, thank you.
No, the only reason is that, thank you. Podiums are always a little short. I'm too tall for almost any podium, but happy to be here. I need to start with a couple of apologies. Here's the first one. Professor McLeod has presented an argument today that's sort of apparently, a distillation, a summary in just a few minutes of a complicated book-length argument. And I'm supposed to comment on that summary. And in doing so, it's very likely that I won't have grasped the full argument. So I apologize for that in advance. Her paper has two parts in her presentation. The first part is about the value of conscience in general, as a general matter. Why should we respect and accommodate conscience anyway? The second part is a more specific argument related to abortion. She argues that although the consciences both of medical professionals who are committed to providing abortions and of those who are opposed to performing abortions are valuable, the former group, that is the providers, should probably receive greater accommodation. Now, it may be that this second argument is the one that most people in this conference are interested in, and I would have some objections to that argument, but time is short. I've never worked in the field of bioethics and so forth, and more specifically, my assignment was actually to talk about the sort of general background and premise of the value of conscience. And so with that second apology, I'm going to focus on the first part of her paper and not the second part. So in our society, we've inherited a commitment to something like the sanctity of conscience. And so we suppose that as a society, we should, if possible, try to accommodate people in the exercise of their consciences, even if we think they are wrong. So a Quaker may object to serving in war because he believes that war is always wrong, and if a society agreed with that view, it presumably would never go to war. So the fact that a society decides to fight a war, maybe for defensive or humanitarian purposes, suggests that the society thinks the Quakers' premise is mistaken. Even so, a commitment to the sanctity of conscience may lead the society to try to excuse the Quaker from military service, and in fact, American law has typically tried to do that. This respect for conscience has arguably been a central feature of modernity, but the matter is also somewhat mysterious, I think, and so I think it's helpful to begin by noticing what we might call the paradox of conscience. We might think of this paradox as growing out of a gap between the first person and third person perspectives. So, from the first person's perspective, to say that I should do what I believe to be right is almost tautological. But from the third person perspective, it's much less clear why other people, or society, or institutions like government should try to accommodate me, or anyone, in acting on beliefs that they believe to be mistaken. In most situations, any such proposition would seem quite counterintuitive. Suppose that after a math test, Johnny comes up to the teacher and complains, on the last question, what is 10 minus 6?